Good evening, Catherine. How are you?
Good evening, Luciana. How are you?
Okay,
I
good. We
thought
have a
we,
special broadcast tonight. When admitted murderers accuse the innocent, the Roger Hillygus story. This is a really serious case here.
this is the Roger Hillygus and the Stuart Handy
Right.
story. And I would like to start with a prayer. I've actually written out this time, so I won't stumble and bumble around. Oh,
Okay.
Heavenly Father, you've instructed us to do unto others as we would have them do unto us. We understand that to mean that we care for those in our household, that we raise our children in the ways they should go, and that we honor our earthly fathers and mothers even into their declining years. Yet we know that as servants of Yeshua and the world run by Satan's minions, that just as the world hated him, it will hate us too. Help us to hear the growing hatred, to bear the growing hatred from those minions who pose as our fellow men and women, and not to bring our disputes into the councils of the ungodly, as you have warned us against. Strengthen us, dear Lord, and your servants, Roger Hillygus and Stuart Handy, for however long their tribulations and ours will last, according to your will, in the name of Yeshua, amen.
In the name of Jesus, amen. Thank you, Catherine.
We could get into, some of the basic facts, which were established by Roger's first notice in May. And if you can put up that May 22nd clip from
You mean the petition?
the petition, yes.
Right. Okay.
And that is, on computer page 2020 of,
Okay.
or wait a minute, it's 6 of 12. Wait a minute. It's from the, this is for those of you who want to go to the Texas court website. You can see the petition that was filed there by Roger through Donna Cartwright, his power of attorney. And in that petition, there were a number of allegations of fact, and that's actually page 20 of 70, where it says summary of facts.
Correct.
You see that, Luciana?
Yes.
Okay. And just the basics. This is, in some ways, a very typical land grab using the accumulated wealth of people who are now baby boomers or older, and to prevent what had been the traditional intergenerational transfer of wealth from one generation to another. Okay, so what we have is that back in August of 1993, when both of Roger's parents were clearly competent, they executed a document called a living trust, or maybe they called it the Hillygus Family Trust. And they named Roger to be their successor trustee for when they became incompetent or upon their deaths. There's no question by anybody that they were competent in 1993. All these facts I'm reciting have all been presented to the people who are now torturing both Roger and Stuart. And they were given 4 opportunities to dispute them specifically. They declined all 4 opportunities. So after 1993, basically, and sometime around 2011 and thereabouts, Roger and his wife began to take care of his parents, and this was met by his sister being quite disgruntled that she wasn't named to administer any of the property, apparently because the parents didn't trust her. She's a realtor, and she swung into action apparently sometime in 2014. She did a lot of other things before that, but in 2014, she and bar member Torvinen, who's one of the respondents, began to try and manipulate that trust, and they tried to get Herbert, also known as Gene Hillygus, to sign documents they prepared that would undo the trust assets. Well, he was clearly incompetent at that point, and I don't think it was many months or years before he died. And he died on August 24, 2015. And so there may be some documents that he signed, they had him sign, and but they were done while he was incompetent, and the respondents have all admitted that.
Yeah, and I guess the sister, Susan, was using
Robin. Susan's the mother. Robin
I'm sorry,
is the
Robin.
sister.
Yeah. Okay. Supposedly, Robin, the sister, had been using monies that was in the trust fund and using it to buy land and other assets for herself instead of in furtherance, right, of the trust purposes.
Right. And Roger had told me, and I think it's in there, that she was looking in their windows and trying to conjure something up so that she could go against her brother, discredit him in some way. And she's been working diligently at that ever since. But this is a typical scenario for what we call predatory guardianship, predatory probate, where there's a perfectly good estate plan, and but there's a disgruntled family member, and sometimes it's not even a disgruntled family member. Sometimes there's these professional guardians, as there was in this case, who scout hospitals and funeral homes and anywhere they might be able to find vulnerable elderly people or their relatives, so that they can step in to become professional guardians. And they do business with the corporate tribunals masquerading as courts. And this is an important fact that everybody I talk to forgets about, that these are not courts. They call themselves courts, but they're not courts. They sure are pretending to be courts, and they're taking on the characteristics of courts, but they don't meet their own definition of a court, according to their Black's Law Dictionary, 4th edition, which is a court is the sovereign and his suite. They are not sovereign. They used to call themselves that, but nobody believes that anymore. And they wanted to use the word sovereign to demonize the people, so they couldn't have it both ways. In any case, once Herbert had died, then they needed to get rid of, and during this time there was, there was an appointment of a professional guardian by the name of Casey Sussman, Fiduciary Services of Nevada, LLC.
And coincidentally enough, the Casey, who they assigned as a guardian, worked on the side, excuse me, as a real estate agent herself, very interested in land and property.
Mm-hmm. Well, that figures, since it's her job to plunder people's estates, including selling their property. And anyway, so Roger unfortunately did not understand that this was all a racketeering enterprise. These were not court proceedings. They were masquerading as court proceedings, but they were not court proceedings. And so he took them at face value in the way we've all been brainwashed. I was brainwashed for 40 some years to believe these were really courts. This was really law. Their statutes were really law. They weren't, but that's what I thought. That's what I believed until I was asked to go ahead and look them up. You think they're courts? Go look them up in Bradstreet, see what they really are. And I did that and really received the shock of my life. Nobody else seems to get why that's a problem. I'll tell you why that's a problem. It's because a private for-profit corporation is there for one reason and one reason only, that's to make a profit, not to do justice, not to send people, into dungeons, not to do any of the things they say that they are authorized by, because they said so, by their own statutes and codes, which are corporate policy, not law. They give themselves power, and then they abuse the power, the power that they even pretended to have, that they made us swallow, or they led us to believe we had to swallow, and we didn't ask questions. We asked fewer questions over time, and their powers increased. Their apparent powers, not their real powers, but their apparent powers, the powers that we gave them by breathing life into their dead legal fiction corporations. And anybody who has been watching some of the Mockingbird Media live streams of these proceedings in their corporate court might notice that Breslow, the so-called judge, oftentimes will refer to his court not as a court, but as Department 8. What? Department 8? That sounds like a department that would be a division of a corporation, doesn't it? Doesn't sound like anything I ever thought of as being a court. Now, sometimes they have many names. They also do call themselves the Second Judicial District Court. But you look them up, you find out what they really are. And that's what Roger and his power of attorney did when they served these people with notices and indicating that the Breslow and Steggy and the rest of them were actually agents of the various corporations with Dun & Bradstreet number, whatever. They could have rebutted this. They chose to not do that. They never rebutted anything. And even according to their corporate policies, they're required to do that. They're according to their Uniform Commercial Code, according to their civil rules, according to their Roman civil law even. There's a concept called NIHIL-DICIT, which requires a response. You're accused of murder, which is what this notice did accuse them of, murder of Susan Hillygus in 2016, in October 2016, right after they abducted her from Roger's care in California. It took them about 2 months to use pharmaceutical products to hasten her death. We call that murder. They don't dispute it. So in the meantime, the plundering apparently continues, and one of the few obstacles to the continuing plunder is the fact that Roger Hillygus is still alive and making claims, including making this claim, which has now ripened into a judgment from the Texas court, which has ordered Roger's immediate release. Well, the people in Nevada have chosen to ignore that and are keeping Roger locked up. They suddenly have pretended that they've grown a conscience and they're going to allow him to have the services of their friends at St. Mary's Hospital in Reno. And if Roger should die there, well, it would be easier to have plausible deniability, wouldn't it, than if he died in one of Barry Breslau's dungeons. Okay. So then, go ahead.
I want to
Yeah,
say
you're going to get into the clips that we have from Roger's conversation with Matt Scarlatus during the period. This is from a period of, I don't know, we don't have them all. Some have been corrupted from July 31st, 2023 through August 17th, 2023, to give you a flavor of the kind of treatment that Roger and others are having inflicted on them at taxpayer expense in these private for-profit dungeons.
Okay.
Do we have July 31st?
Let's see if that's the one I'm pulling up. Hold on. I
This
have
is
right now. Okay, this one is regarding the meds. What the deputies saying to them regarding the meds. Hold on just a second, and we'll let you hear that. Okay.
You know the date on this one? Oh, this sounds like August 17th.
No, hold on. This one is, from August 17th.
Mm-hmm.
Okay.
All right. Well, can you hear it?
Yeah.
Okay, because I'm not hearing it.
Okay, so were you?
So you can actually hear that? I didn't hear anything.
No. Okay.
No.
Well, I had it playing. Hold on.
I took notes on what it was about. I hope others can hear it.
Yeah.
What it was about was this Detective Lang, or Deputy Lang, made sure that Roger knew that he was not going to get his meds with water or with food as prescribed.
Right.
Okay. They were going to make a point that not happen. Okay. Do you have any of the others?
Yeah. Okay. We have this one about the body cavity search that they wanted to do, looking for a battery, it appears.
A battery to a remote for a TV.
Right.
And this involved a full house shakedown for a missing battery.
And this is what they're putting him through. It's just really bad. Okay. Okay.
Maybe I have to click on the.
Oh, can you hear it?
No. Can you?
Yeah.
Oh, okay. Is anybody else still on? No, well.
Yeah. If you can't hear it, I'll just go ahead and stop it, and you can explain then. You can explain what's going on in it. Okay.
Okay. Yeah, we had to do all kinds of things to the file, didn't we? You had to compress them and do all kinds of stuff.
Yeah.
Probably by the time we could listen to it, it could no longer be transmitted.
And
we lost modern technology.
Yeah, we lost Stuart. I hope he's going to come back on here.
Yeah, we lost Keith too, didn't we?
No, Keith is still here.
Okay, I just can't tell.
Yeah, Keith didn't hear it either. Okay, so there was a. Stuart said he's switching over to the YouTube link, but we can't talk to him from there.
Right. Okay. Keith couldn't hear it either. So, anyway, if anybody wants to email me, I can send it to you, and so you can actually hear. I have 4 recordings dated July 31st, where and they are as attachments, and you can actually hear those. And you can email me at wljaradio@aol.com. That's wljaradio@aol.com. And I will email the few of you who care enough to want to hear any of these.
Right.
This the July 31st one dealt with Deputy Rosen having basically a large temper tantrum over an African American guy who was being held also at the Reno jail, who was getting hot water for coffee or something, and wasn't walking where he was supposed to walk or something, and he became irate, and it ended up with a half a dozen of their employees piling on the guy, beating him, and I don't know if Roger ever saw him again after that. He was screaming.
I think Stuart moved over to the YouTube link, but we can't hear him. I just asked if he would come back over to the StreamYard so that we could pull him up and talk to him.
Yes.
Okay.
Okay. Yeah. So he's just listening to it. Yeah. Instead of, All right.
Yeah. But I kind of wanted to hear him.
Then there was the August 8th tape with Deputy Herman, Manuel, and Moreno, who threatened Roger with lockdown for being disrespectful. And that was because Roger was on the telephone, and they like to choose to interrupt his telephone time and demand that he do something else.
When is the last time? When is the last time you talked to him, Catherine?
August 22nd.
And that's very concerning. Why? Weren't you speaking to him daily? I think.
Apparently, according to Stuart, Roger is being prohibited from using the phone. And in this, they were getting started with that they would try and get him to do something else while he was exercising his telephone time. go to a meeting, go take a shower, go do this, go do that. Things that they weren't concerned about unless he was on the phone.
Right.
And he declined, and they said that by declining, he was being disrespectful and threatening. Yeah. And in the call, which Matt Scarlatus was on as well, Matt was commenting that it was crazy. He said there was nothing threatening about what you said. Then there was the other two. I think the other two videos we've
audio recordings. Yeah, one of them
Right.
that was really just heartbreaking. That they would put this innocent man through a full body cavity search. They said they were searching for the battery to a remote control. So they forced him to go through a full body cavity search, which I have heard is really just disgusting and traumatic what they do.
Yes. They put everybody through it. And
from what I understand, Roger has now been placed in the infirmary and put into a red outfit, which designates him as dangerous and a risk to the safety of staff and other inmates. That's recent.
Oh, okay. Your information is more recent than mine.
I'm getting this right now. So he's been placed in the infirmary, put into a red outfit, which designates him as a danger and a risk to the safety of staff and other inmates.
Yeah.
This is outrageous. Yeah.
We might want to point out that at the time that Roger was kidnapped on his way back to his Texas home in 2022, October, he weighed about 180 pounds, and this is according to one of his conversations with Matt Scarlatus. He's now down to, and this is with clothes after a meal, while having to go to the bathroom. They weighed him at 155, so it's more like 150. He said, I haven't been as low as 150 in maybe 40 years, he said. And he wasn't in a wheelchair when they abducted him, but he is now, and they want to take that away from him too.
There was a situation, what was it, last week or so, that they rolled him out to the yard on a very hot day, Catherine, and what happened that day? They left him up there with no water.
For a couple hours until he had a grand mal seizure. Yeah. And then they put him in the infirmary, which apparently is its own special kind of hell. And they want to argue about whether, he needs the wheelchair or not. He's developed all kinds of medical conditions he never had before.
Yeah.
He had a few to begin with, but we're being controlled.
He suffered from heat exhaustion and suffered a seizure due to them purposely putting him out on the in the yard in that extreme heat and just leaving him out there for so long. Can you imagine? And he's in a wheelchair. So, it's not like he can just get up and walk back in. This is torture. This is torture.
Yeah. Okay, so
this judge, the sheriff, the deputies, they've taken it upon themselves to be the jury and decide that he's guilty and punish him in severe ways such as this. And he has not even, it's not been found guilty by anyone.
No. In fact, in part of his notice, they've admitted 4 times that he caused no injury, harm, or loss to anybody, not to his mother. And we were getting to that. The first abduction of him and his mother was in 2019, when they went to visit relatives in California. And that's a lot of that and other things are covered in the link called Searching for Delilah, I think it's called.
Right.
Yeah.
I could play part of that if you wanted me to. I thought that was
We might come back to it, but yeah, if you want to put a link to it.
Okay.
But they were all in a tizzy over that he came in and there's video on that post of him, and I believe that Stuart was with him, and they were inquiring about the pharmaceuticals that Susan Hillygus was taking, that there was nothing that was treating an actual medical condition. All of the pharmaceutical products were treating anxiety. Gee, why would Susan Hillygus have anxiety after having been kidnapped along with her son, from visiting relatives in California? They took her too, and they took her back to Nevada, and she was in like 2 or 3 different care facilities for during the last 2 months of her life, and they did manage to kill her and they've admitted they killed her on, I think it's October 16th, 2019. Before her death, there's also a proceeding that is covered on that other video in which Robin Renfro, the sister, and various bar members are discussing what they think happened, that they were not present when it happened, and they gave their version of Roger and with Stuart witnessing that they peaceably removed Susan at her request, and that's been admitted to by all the respondents. She was removed at her request and went with her son happily. In fact, there was a couple of the other people in the nursing home saying, take me too, because it was a hellhole.
Yeah. She wanted to be taken out of there. She'd asked them, please take her out of there. And I mean, she had a black eye. She had soiled pants. It's ridiculous. And from what I understand, Robin Renwick is really the top criminal in this whole situation.
She was really pushing those pharmaceutical products. Yes.
She's the sister, correct?
Yes.
Yeah.
And she was very angry that she was not named as the successor trustee for good reason.
And was found to be taking money out of the trust for her own personal use.
Right, and that was in the notice as well.
Right.
That they all admitted to.
Jesus.
They kept trying to, and they did succeed in changing the trust. Well, they didn't really change the trust, but everyone pretended that they had changed the trust, and they took the authority that Mr. and Mrs. Hillygus had originally given to their son, Roger, and they just assumed it for themselves.
Isn't that something?
Yeah.
It's Robin Renwick. Yeah.
Robin Renwick.
That's just unbelievable that, people work so hard for everything that they have. They reach their golden years and start a trust to make sure that if anything happens to them, everything that they work so hard for goes to where they want. Then when they get old enough, and then they get locked, it's unreal that so-called court, those men in black dresses in those corporations, can just sign off on a piece of paper and just change everything and say, pretty much exactly what they didn't want. They didn't want it to go to her. They didn't want her to be in charge of it. They wanted their son, who they felt, and that they have known him his whole life. They felt he would be the proper person to handle this trust. A so-called judge is just going to sign off and say, oh, well, we're going to change all that. Yeah, we're going to change it and give it to her. Give it to the sister, who the parents didn't think could handle this properly, but we're going to give it to her.
They had to do a lot of fancy footwork to get there, including that's why they had to basically, twist Herbert Hilligus's arm behind his back to get him to sign what they wanted him to sign. I don't know if he ever even did sign it. They pretended he signed it. He would have signed it. He might have signed it. Regardless, he wouldn't have been competent in 2014 to have signed it, even if he did sign it. And they've admitted all that. Okay, so then, Roger continued to believe that he could invoke the power of a real court. He thought maybe if he went to a federal district court, so-called, not understanding that they too are private for-profit corporations. They too will reframe the issues so that their buddies and their fellow bar members will make the kinds of, tens of thousands in fees that they demand. And the Delilah video on YouTube shows that.
Yeah, I put it in the YouTube on the comments. And what we usually do, our live streams are on the live section of our YouTube page, but we download them and then put them again on the video side. So when we download and put on the video side, I will put that on that side as well. It's on the YouTube page of whatever happened to Delilah. Is that it?
Yes.
Yeah.
Right.
No, it's called #Where is Delilah. And It was just posted a few hours ago, yesterday. It's got 110 views so far, but it definitely needs to be shared.
We have. I know I've tried to comment on it, and YouTube always deletes everything.
Right. There's supposedly I don't know, over 8 or 9 comments, but only 2 or 3 comments are showing because they continue deleting the comments on there.
Yes. So, as is typical in a predatory probate, they had to get and they did get fake guardianship over Susan and evicted her and evicted Roger and his wife from the family home, which was in the trust and that they were charged with administering. And of course that involved violence, because everything these people do involves violence. And a lot of the personal property that belonged to Roger and his wife was taken along with trust property.
Yeah.
So, and I believe there were multiple restraining orders to make sure that Roger could not be with his mother for any of the rest, the remainder of her life after the California abduction. And then I believe it was in 2019. Admittedly, Roger established his domicile in Texas, and that's the reason for invoking the jurisdiction of the Texas Common Law Court, the original Republic of Texas. And just scrolling down to and I think that would be page 6 of 12, from the judgment.
So what actual page is that on? Because I just have the
computer page 5, and it starts at 5 and 6. Yeah, paragraph 12. This 3-notice process that Roger did is well known. Not only it was originally established in the Bible, Matthew 18:15 through 17. It's also totally consistent with man-made corporate policy, specifically uniform commercial.
This is page 4, page 5.
Bottom of page 5, and then going on to page 6.
Okay.
Paragraph 12 starts at the bottom of page 5 and goes on to page 6. This is in the judgment part.
Oh, that's okay. I'm not sure what page the actual judgment starts.
I'm
down to page.
Are you on the judgment or are you on the petition still?
It's all together as one, as a 70-page document.
Well, the judgment should be the shorter.
It would be
the shorter document, only 12 pages. The petition should have all the notices attached to it and be much longer. I'm referring to the shorter document, the judgment. It's a 12-page document.
Okay, so this is a petition for judgment. Okay, that goes on. All right, so and the petition for judgment has the notice.
We don't want the petition, we want the judgment itself.
Okay.
The shorter document. And people can look that up for themselves on the website known as...
Yeah, I'm having trouble finding it.
It's rtcacl.net. That's RT, Republic of Texas, cacl.net. In any case, I'll just summarize it. That we have heard from some of them or some of the snide comments that don't get censored. That this process, there's something wrong with this process. There's nothing wrong with this process at all. It's well known in Roman civil law, is well known in the commercial world. You can accept a contract by conduct or by silence. And they accepted it both by their silence and by conduct. Yes. The case is called Cartwright versus Breslau because since Roger was locked up in a dungeon, he couldn't bring the suit, or they have no way of allowing him to sign documents in their dungeons. So he had previously given power of attorney to Donna Cartwright to say to put in here exactly what he instructed her to say.
Yeah. Okay. And as you can see, I can only click on the actual. I can't click on separately on the judgment or the petition or the summons. I can only click on what it allows me to click on right there.
Okay.
And, okay, the signed final judgment. Okay. Sorry about that, Catherine. Okay. All right, here we go. I'm sorry. Can you see that okay?
And what's that? That's the judgment. Yeah. The judgment was entered July 11th. No, wait. July 31st. I thought it was later in July than that. Yeah, July 31st. It's a 3-judge panel. And let's see, we've got some comments in the chat. Keith asked what kind of treatments is Roger receiving. He's receiving magnesium supplementation. He receives some sort of medication for his heart, and it's quite an array of supplements or pharmaceutical products that they treat him with. And he has balance problems. That's the reason for the wheelchair. And I believe there's neurological and bladder and bowel problems, and has been chastised also for not snapping to attention quickly enough, exiting his cell when ordered to, when he was on the toilet. And, similar kinds of indignities like that, and where he's just being punished for his medical conditions that they brought on. Well, anyway, a lot of there apparently has been some sort of an effort to put together a common law grand jury in Nevada, although I've not had, a lot of cooperation with people in Nevada who are in the common law movement. I hope that will change. And because the judgment from Texas orders Roger's release, it orders, compensation for, the other crimes, for the wrongful death of Susan Hillygus, and it orders injunctive and declaratory relief as well as monetary, but it doesn't provide for the punishment of these people, although it does find that they committed the criminal acts beyond a reasonable doubt, as well as by a preponderance of the evidence. In an abundance of caution, giving these people who don't provide any due process to us with due process, since they are arguably, entitled to the protections of the Fifth Amendment, which would require a grand jury to issue a true bill. It's really important for the people of Nevada, or even the people of Texas, but preferably the people of Nevada, to make their voices heard and form a common law grand jury to issue a true bill and in a judgment that they could then also form a common law court to implement. What I see as the purpose of this is to enable people. We're reaching a boiling point, obviously, and we don't want people to get themselves in the position that the January 6th protesters were in, or that Ammon Bundy has gotten into. Protesting does nothing. All it is a demonstration of one's weakness and one's frustration. We don't want to be labeled falsely, of course, as insurrectionists. We want to be seen as what we are, which is enforcers of the true law, the true criminal law, the true word of God, crime stoppers, in other words. And that's what we can be if we will form our common law courts and grand juries. We can do this, but we have to stop submitting our disputes to the councils of the ungodly. And that's what we're doing. We're submitting those disputes to private corporate entities whose only purpose is to exploit us, make money off of us and our loved ones, and we expect a good outcome. It's not going to happen. I mean, yeah, we can hope that even there, you know, that some jury, so-called jury, will see through the lies. However, Barry Breslow has already announced on multiple public platforms that he's going to have a secret trial jury to decide this matter.
Yeah.
You know, these criminals, admitted murderers, just love secrecy, obviously. And yeah, go ahead.
Do you want to play just a little bit of the last that we heard from Roger, which was on the 23rd? He was speaking a bit at the hearing.
Okay.
Okay. Let me stop this. I hope you can hear this. Hold on. Okay.
This
Can
was
you
a
see that?
YouTube.
Okay.
Yeah, I can see it. Yeah.
Okay. Let's see if we can hear him there.
Can you summarize for the court? I need to put it under oath. What is new? No.
I'd like to preserve an objection. I'd like to make a record for an appeal, and I'd like to do that under oath.
I'm not placing you under oath, Mr. Hillygus.
Okay.
This is, if you have a legal argument as to why the court should not proceed to trial Monday, please tell me what it is.
All right, so I'm going to do this. Everything that I say is the truth, the whole truth, and nothing but the truth, so help me God. This case should be dismissed for cause. Let the facts state that this case is based on false statements, lies, fraud, and perjury. I maintain my innocence, that no crime has been committed. I've been in these same clothes and socks and underwear for a week. I was only given new clothes this morning. No toothbrush for a week. I have to brush my teeth with my finger. The rules say that you must brush your teeth 2 times a day. I've been denied a shower last night and this morning. Before court today, the rules say that inmates must shower daily. I'm not able to shave completely or get a haircut for the last week or more. This is punitive and punishment. I've been denied phone use after court yesterday and all night, now for over 36 hours. And as a whistleblower, that's a violation of my rights. I've been denied tier time last night. I've been locked down now for 36 hours plus. This is punitive and punishment. I've been denied the message app on the tablet. It was removed by—
Hold on a second, Mr. Let me hit the pause button, Mr. Hillygus. I'm looking for legal cause why this case should not go forward. Hold on. Mr. Steggy, you want to address the court?
Only that, as a court, just stay with Mr. Hankey. The court we have things to do this morning that have nothing to do with this. Perhaps we can take up this at a later date, or at least once we get through the matters that we have.
Well, if Mr. Hillygus is coming to a summary here or conclusion, then we'll move forward. If it's going to be longer than this, I have other matters we have to get to. Go ahead, sir.
What I was saying is the message app on the tablet was removed. That's a First Amendment violation. I was not able to send or receive messages after court yesterday. I've been denied my prescribed medical supplement triple magnesium for over 36 hours, 4 doses. I'm still not provided with a witness list by the DA, and that's a violation of the court rules, and there should be a show cause.
Hi, I'm Kelly Brown, host of today's Urgent Stock Market.
You know, a lot of folks think that they're going to deal with the nitpicky details, and you know, when you're being kidnapped, I guess, and all avenues seem shut. You know, all doors to true freedom seem to be shut down. Then you're going to focus on the minutia of the terms of your kidnapping.
And even did you notice, even when he got a moment there to speak, when he started speaking about the abuses he was going through, you know, and the unjust situations he was dealing with there in the jail, the prosecutor stood up. Oh, we don't have time for this right now. You know, we have things.
Oh yeah, they never have time for hurry it up. Yeah, it's just your life, but hurry it up. Yeah. We don't want to hear it. We already understand your position, whatever. We don't care.
The bottom line is he's declining quickly. Being deprived of things he's supposed to have. And this is a nightmare.
Yeah, time is not on his side. So I don't know that anything he would say about not being ready for trial would be in his interest.
And trial is supposed to be tomorrow?
Supposed to be tomorrow. Although, according to Stewart, it's probably not going to be tomorrow. And this will fit in rather nicely with their business plan, which is that, you know, you're going to have Roger and Stewart's attorney and everybody. They're not quite ready, and they need a few more weeks and to file this and file that, and that goes into the court registry investment system. Every time they file, makes money for the fake tribunal calling itself a court.
And what about Stewart saying he does not want this public defender, this attorney representing him? And the judge has to think about whether or not he'll allow Stewart to represent himself when you have an absolute right to represent yourself. You know?
Well, it's an insane system, and they break their own rules all the time. You know, attorney-client relationship is a contract. Contracts require consent. And if the consent is gone, then you don't have a contract anymore, even though somebody else says, yeah, but you should have consented. It doesn't matter. It's not a contract anymore if you don't consent. And Stewart stopped consenting.
Yeah, we just found out the trial for tomorrow was canceled. Thank you.
Yes. Right. So they're going to drag it out. And Stewart concurs that they do intend to kill him. And time is on their side. So the more, you know, everybody's taking time to get their ducks lined up for.
And the thing is, they'll blame Roger. Well, we couldn't have the trial because Roger said he wasn't ready. Well, why isn't Roger ready? They're not providing him with the things that he needs for trial. You know, the witness list and all types of stuff. And here in Ohio, there's so many cases where, such as the Tony Viola case that people can look up at freetoniviola.com, and several other cases where people are put in prison, a jury finds them guilty, but there was tons of exculpatory evidence that would have found that if had a jury heard it, they would have found that this person is innocent. But the prosecutor withholds this exculpatory evidence and does not provide it.
Mm-hmm.
And this is what's happening here as well.
That's Brady versus Maryland. That was decided, 4 decades ago? that the prosecutors have a duty to disclose exculpatory evidence to the defense. Well, you know what happens with that? You can't enforce that rule. It sounds all warm and fuzzy, but it's nonsense, because the prosecutor can always say, well, you know, I had this evidence. It didn't seem exculpatory to me, so I didn't disclose it. That's what you get. It's nonsense. It's nonsense.
Catherine, supposedly now the trial for tomorrow was canceled because Roger and Stewart agreed to a settlement conference. So they're going to have a conference to try to settle this, which means the prosecutor and the judge are going to try to get them to agree to some kind of plea deal, you know, which is what they do.
Right. And I would say, you know, if there's going to be some sort of a plea deal, I would just to get out of there, because any agreement that would be made while being tortured to death is no agreement at all. And there's this has been well known in their fake corporate system for a number of years. And there's a case called State versus Alford, as ALFORD, and it became known as the offered plea. And that the offered plea of guilty, which is guilt while maintaining innocence. Yeah, because the corporate system understood that they were convicting and twisting arms of lots and lots of people into plea deals, people who were maintaining their innocence. And they wanted to make it easier so that it would go through the system quicker, because that's what it's about. The quicker they run them through, the quicker those CRISP funds get distributed. So in the offer plea of guilty, you say, yes, I am innocent, but I'll plead guilty because probably y'all will be able to rig the evidence so that some jury will find me guilty anyway. I don't want to risk that, so I'll plead guilty to get a plea deal.
All right. So in lieu of trial, I guess Stewart and Roger agreed, in lieu of trial, they'll listen to a proposed plea agreement that they might have for them under Nevada Supreme Court Rule 252. So under that rule, they're going to have a settlement conference and listen to what plea agreement they may offer them. And if you watch the last, what is it called? Nevada
our Nevada judges.
Correct. On our Nevada judges, you could on YouTube, you can find the last hearing. I think was on the 23rd, and you can hear, I think, both Stewart and Roger admitting that when they were offered a plea deal, it was more like a threat, more like you could take this plea deal because you're not going to fare too well. And you're not going to fare too well in prison, and threaten Stewart. You know, a cop isn't going to do too well in prison. You know that, right? I mean, that's a threat. And I guess there was a discussion with another attorney regarding a new proposal of defer and dismiss. Do you know what that is, Catherine?
Deferred sentence. Yeah, where they said, well, you know, just plead to it, and if you're a good boy for X number of months, years, we'll dismiss everything. Yeah, and that way they get to, you know, make their money with their federal contracts, and they don't look like the murderers that they are. Because after all, why would they agree to something? You know,
my issue with this is how do you put your trust in these evil people who have done so much damage so far? Now you're going to take, if they do take a plea deal and with this defer and dismiss, okay? Let's say, for instance, okay, they'll agree to some lesser charge and they'll get probation for a year. My question is, how do you trust these people that while you're on probation, maybe you flick a cigarette in the street or something, and
Right,
get
that's-
pulled over and run right back in through the system again. Oh,
That's right.
well, you know, you committed a crime or you jaywalked. Oh, you know, too bad. I
Right,
mean,
right,
it's
right.
almost like, you know, they're going to be looking to win one way or the other and
Yes.
continue making money off you being in their system. So
Yes.
how can you trust them? I don't, as a Christian, I can't see trusting such evil in any way, shape, or form.
I
You
heard
know?
I heard someone saying that he'd been harassed for so many years, and his family destroyed. Well, not as badly as Stuart and Roger's family, but still. And he was saying publicly, if they would just tell me, I would give them everything I have just to be left alone. Well, how would you ever know? We promise. We swear, pinky swear. We will leave you alone. Just give us everything you have. Yeah. And you think that their word is worth something?
Right,
Really?
right. I'm personally, I couldn't trust them for nothing,
No
But the
way.
problem is they're so dirty that they will they will continue. There'll be continuance after continuance, and for all you know, that it'll be another couple years before they see a jury or anybody hears.
Or before they even do the deal. Yeah. Right. And then, you know, what if they're required to report to a probation officer, and the probation officer can't make an appointment, and there's a mix-up over whose fault that is? Yeah, like you said before, that can turn into a probation violation that brings down the full maximum amount of penalty that the original charge could have carried, not just, you know, the 1 year or the whatever. Yeah.
So I'm not sure if Steege is the
Steggy is what they call him, I think.
I'm sorry?
Stege, the
Correct.
assistant DA, Steggy.
Right,
Yeah.
right. The district attorney, yeah. So he first threatened Stewart, you know, trying to get him to take this plea deal and threatening him, saying, you know, a cop is not going to do well in prison. And then threatened Roger. I mean, it's not even offering a plea deal. It's like, you're going to take the plea deal, because if not, something really bad's going to happen to you.
They used to call it, when I was practicing criminal law, the trial penalty. If you don't take the deal and you insist on going to trial, you're going to be very sorry you did.
Right.
Yeah.
Well, they don't want a jury hearing all the crimes that have been committed against these people, against Stewart, against Roger, against Roger's mother. They don't want it. I mean, they don't want the actual facts out there, and they don't want a jury to hear this.
Even with their secret jurors comprised of their country club friends. They
Right.
don't think they could even run it past them, apparently. That's strange. There's, of course, we know this is part of a land grab and just general thievery. There was just on the 24th of August, and I'll send you the clip to this. This is it's not a predatory guardianship or predatory probate case, but it involves a land grab.
Mhm.
There was an eviction proceeding, and there was an eviction proceeding against Roger too in the early stages of this predatory probate. Linked to a Pittsburgh case where they were labeling the man that they were attacking as a sovereign citizen.
We are not sovereign citizens.
No.
Absolutely not sovereign citizens. But yeah, they will try to label us all that so that they can label us domestic terrorists and as we know, and we can share the PDFs with you of the FBI training law enforcement, or what they call law enforcement, to that people that assert their rights in any way are labeled sovereign citizens, domestic terrorists, and should be looked at as very dangerous, very dangerous. So you got to pull out your guns if they assert their rights, because this is insane what's happening here. My God.
The title of this article is quote unquote, sovereign citizen shooter dead after 6-hour gun battle with police. Apparently this man, who's a veteran, had been taking care of his brother until the brother died, and had a claim to the brother's home. I think the brother, had wanted him to have the home. And so I don't know the details, but according to the article, like in Roger's case, they had to make a big thing out of it. Helicopters, SWAT teams, to get this.
If you want, after we're done with talking about this, I can play that what was posted yesterday, that YouTube video, the hashtag Where's Delilah.
Okay.
For those that are not aware of from the beginning what happened all through I think they did a very good job of putting it together.
I think so too. Yes.
So we'll play that after if people want to stay on and watch that. Okay.
Or we could just put a link to it in the comments tomorrow.
Okay, we can do that too. You know what I'll do? If you want, I'll play like the first minute of it.
Uh-huh.
Only because you can hear the 911 call from the nursing home.
Oh,
where
yeah.
his mother was, how they talk about that he came and kidnapped his mother, which is insane. Okay, hold on.
Yeah, I'm wondering are we better, as far as the censors, are we better off putting it in on this broadcast rather than putting a link to it in the comments, since YouTube loves to delete our comments, even on our own stuff.
Right. No, we could do that. Okay.
Yeah.
Okay. All right, I'm going to go ahead and play this. Hold on. I'll play just a little bit of it, okay?
Okay.
Is 6155 Stone Valley Drive.
6155 Stone Valley Drive, Stone Valley Terrace.
Yes.
What's the emergency?
89523.
What is the emergency, please?
We have a kidnapping. His son has come in and stolen his mom.
Okay, so is his mother having dementia or Alzheimer's?
Yes, the son there's an order that he has to stay away from her.
How long ago did this happen?
10 minutes ago.
On June 14, 2019. Dear Steve Moss, it appears as though you're not taking my verbal request to you over the phone. Discharging you as my attorney, seriously. Let me refresh your memory about the events of that call. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and the hand-delivered to your office secretary, Cynthia, and original hand-signed letter by Roger, discharging you as the attorney representing me and the Hillygus Family Trust. You told me that paying the final bill would be $2,000. I'm confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter.
911, what's the address of the emergency?
I just called in. I'm at Stone Valley Memory Care. It's 6155 Stone Valley Drive.
6155 Stone Valley, and what's going on there?
We had a kidnapping.
You had a kidnapping?
I just talked to somebody at length in regards to this. I said some additional. I have a phone number for the kidnapper, which is their son. That's court ordered to stay away.
Hold on 1 second, okay?
Okay, thank you.
I'm just trying to find the call, so give me just a second. What's the information that you wanted to give us?
So I'll go ahead and have that. If you want, I can play that at the end in case, yeah, you know. From what I understand, Roger was, I'm not sure where I'm getting an echo, but Roger was green lighted by the Los Angeles. Hold on. Roger was green lighted by the Los Angeles County Sheriff's Office. If there's a shot to be taken, take it and take Roger out. If he had gone near any window, they would have shot him.
Really? I didn't know that.
Yeah,
I just that part.
Yeah.
Yeah.
And when they arrested him, hold on. And when they arrested him there, he was tased 3 times in a row. Did you know that? Did you know that, Catherine?
I knew about the tasering. Yes.
Wow.
He had been asleep when they were.
Right.
They like to do things about 3 or 4 in the morning.
Well, what I'm going to be playing at the end of our broadcast, which was again posted last night by a YouTuber called #WhereIsDelilah. In there is several police body cam videos that show a lot. So they'll want to be watching that. I'll put the link also. They might remove the link. I don't know. YouTube might, but we'll go ahead and play it.
Mm-hmm.
All right.
There's at the 19-minute mark of that Where's Delilah video, there's testimony, and this is so common, where the attorney says this happened and that happened. He refers to Roger and Stewart as being a goon. Stewart, of course, was a 30-year veteran in their sheriff's department.
Who does that? The police or?
No, the attorney. Attorneys love to testify. This happened and that happened. Were you there? Don't think so. Were you sworn in to give this testimony? I don't think so. But they do it anyway.
They do whatever they want in there. They don't follow any. They don't. It's. I'm sorry, but it's a shit show in there, and I choose not to step in the devil's sandbox unless I'm dragged in there.
Also testified about things that she was not present for. She testified about what happened when Roger and Stewart were present, and jumped through all the hoops, notified everybody exactly what they were doing and why they were doing it. And she gave a different version, and she said she knew what was going on in the minds of the people who worked at the nursing homes and why they did this and why they did that, and they told her this. Totally hearsay. She was not there, but they let her just. That was that hearing, that so-called hearing where it was just her,
right,
and Casey Zussman and Todd Torvinen. All 3 of them admitted murderers. Yep. And none of them have any firsthand knowledge of anything. And that's even in their system. I don't know if we want to do this or not. The predatory guardianship fiasco has been going on. I think maybe so. If you go to activistpost.com and tag my name, Catherine Hine, you can get some articles I wrote, including a book review of a book called How Judges and Lawyers Steal Your Money. and it was about predatory probate, and gives example after example. This was from 7 years ago. This was also exposed as a big national problem in the Wall Street Journal. Nobody did anything about it, and it just got worse.
Jesus.
This is not new stuff. And if we don't stop it, folks, with our common law courts and grand juries, it's going to continue and it's going to get worse.
Yeah.
And you might hope and pray that it happens to somebody besides you, but that's still not going to protect you.
Right.
You're going to have to step up or it will happen to you. Let's see if there's anything else that I was going to bring up.
I have the website for the Republic of Texas, a common law. I have the website running across the bottom for anybody who wants to go onto the common law court of the Republic of Texas and pull up on the docket page. They can find the petition and judgment with all of the affidavits and proof of service and notices of liability that were served upon these criminals that have done this to Roger and his mother and Stuart. And those documents are all up there, and you can see the website running across the bottom, which is www.rtcacl.net. And it would be on the docket section. Oh, I'm sorry. I muted you for a second because there was some background noise, Catherine.
Okay.
And I think Choi was also on the YouTube page, and Choi did a fabulous job of helping the Republic of Texas get their common law court website up and running. So we thank Choi Danella
Yes.
for that. It was amazing work.
Mm-hmm. Yeah. Okay. Well, if people want to know what they can do, I would say, if you go to our website, our common law website at occr2021.com, you can see a contact us subpage, and you can find out how to reach us, and we will help you establish a common law court in your state republic as well. Because you can have a grand jury all you want, but if you don't have a court to take a grand jury true bill, you're not going to be able to get very far. We have to start creating the infrastructure we're going to need so that we're not going to be flailing around in these fake corporate tribunals or getting ourselves labeled as insurrectionists by futilely protesting and putting our lives on the line. So we are getting, I see signs slowly but surely that we are gaining the upper hand, and there are people in their system that are leaving it because they can't stomach what they've become a part of.
What small town was it that the entire police station recently quit? The entire police station. It was a small town. I forgot where it was. And this was recent.
Was that in Ohio?
I don't think it was in Ohio, but I don't think so. I can't recall offhand, but yeah, the entire. We'll find it.
Well, and also there was the town of Mayfield, California, where the people of the town decided we've had enough and we're going to fire everybody, and they hired back a few essential services, and we don't need them. they decided we don't need these civil servants at all. And, we need them about as much as the body needs the tapeworm. And they did just fine. This was 7 or 8 years ago. Town of Maywood, California, reported by the New York Times, which is amazing. They would report honestly about this. The sky didn't fall. They did great. And, I think I've mentioned that in previous broadcasts. So the true value and the true wealth comes from the people, not from these corporate parasites. And we've got to stop bowing to them.
Right. We need to start practicing our faith and showing that our only fear is the fear of God and not
Absolutely.
the fear of man.
Absolutely right.
We really do need to practice our faith and only fear God and trust that He's got us. I'm going to be praying. We will be praying a lot for Roger and Stuart in this case, as we do for many others. And
too, and I couldn't find the clip from Ammon Bundy, who had part of the clip was this was in Idaho. A bunch of so-called, corporate sheriffs pulling up to harass him. He's been harassed for years and years. And he used Shauna Cox's peoplesrights.org process to connect with other people. And this is something you wouldn't have to use peoplesrights.org if you don't want to, but we have to have a way of networking with each other within our state republics, but preferably within our own areas with others, so that if you get harassed, I will drop everything and come and be there with you, not with an AK-47, but with a cell phone taking photographs. And he had that going on with him, and that's all it took. Sheriff's deputies left. They don't, especially in smaller towns, they don't want to walk down the street and have people point at them. Oh, there's that admitted murderer. Do they? I don't think they do. But we've got about 25 of them labeled in the Roger and Stuart matter. Admitted murderers, all 25 of them, and more. There are others too, because just that are their underlings and their superiors. The current so-called governor of state of Nevada is one of the murderers. That needs to be well known by Nevada people. I thought Nevada people cared about their rights as free people under God. I don't see a lot of that myself, but maybe it'll come. We pray that it does.
we pray that it does. And we pray that it comes soon. We pray that it comes soon. I don't understand how anybody with aging parents right now, let's talk about the state of Nevada, could know about the Roger Hillygus case and not be standing up, knowing this could very well be knocking on their door in another month, another year for them. I mean, if it happened to Roger, it could easily happen to them coming up soon here. So I really think that the people of Nevada need to stand up for Roger Hillygus and for Stuart for doing the right thing and being taken down for doing the right thing.
Mm-hmm. Yeah. And you might think, oh, it couldn't happen to me. I'd get a better attorney to draw up a better airtight living trust. No, I don't know. I've seen probably 30 of them where there was nothing wrong with the way the trust was drawn up. The problem was probably having a trust at all. There's a better way of doing it probably that would reduce your risk with a common law private membership association. And at least that way you can maybe keep the details secret. We'll see. But anyway, we don't know. I have a feeling that tomorrow is going to be more of the same as they continue the torture of Roger and Stuart. But I think it would be in their interest to insist on the fake jury trial.
Yeah,
Whatever the enemy doesn't want is probably what we want.
all right. Well, we definitely want to let Stuart know that he is in our daily prayers. And we hope that he will relay the same message to Roger when he sees him again, that we are very concerned and we are counting on a miracle. That's because that's how our God works. We are counting on a miracle.
Absolutely.
And we want him to stay strong and keep praying.
Okay.
Because there's
All right.
you can't count on the guy in a black dress up there doing the right thing.
No.
Any of them. It's not going to happen. So there's going to take a lot of prayer, and that's what you guys are getting from us. You know, we ask everyone out there who's watching and knows about this case to please continue praying daily for Roger and Stuart, because this is just unreal.
Mm-hmm. Yes, it could be you tomorrow. So we'll be back at our regular Thursday time slot. I don't know if maybe by next week we will have switched from YouTube to Odyssey, but YouTube is starting to become pretty unbearable.
Yeah. Okay.
We'll let you all know. And
do I have to move out?
yes.
Catherine?
Yes.
Okay. So we were gonna end by going ahead and playing that that video by YouTuber, right?
Okay. Right. Okay. Sounds
right.
good.
So we also want to thank everyone who's watching or everyone who will watch. And we'll go ahead and end by playing that YouTube video that was just posted yesterday by a YouTuber named #Where's Delilah. And it talks about the Roger Hillygus and Stuart Hand story, and has a lot of police body cam video footage that you might want to see as well. All right. Thank you, Catherine.
Thanks, Luciana.
Okay.
His son has come in and told his mom.
Okay, so is his mother does she have dementia or Alzheimer's?
Yes, he does. But the son there's an order that he has to stay away from her.
How long ago did this happen?
10 minutes ago.
On June 14, 2019. Dear Steve Moss, it appears as though you're not taking my verbal request to you over the phone. Discharging you as my attorney, seriously. Let me refresh your memory about the events of that call. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and a hand-delivered to your office secretary, Cynthia, an original hand-signed letter by Roger, discharging you as the attorney representing me and the Hillygus family trust. You told me that paying the final bill would be $2,000. I am confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter.
911 with the office. If you want my name,
I just called in. I'm at Stone Valley Memory Care. It's 6155 Stone Valley Drive.
6155 Stone Valley, and what's going on there?
We had a kidnapping.
You had a kidnapping?
Yeah.
Okay.
I just talked to somebody at Lynch in regards to this. I had some additional. I have a phone number for the kidnapper, which is their son. That's court ordered to stay away.
Hold on 1 second, okay?
Okay, thank you.
I'm just trying to find the call, so give me just a second. What's the information that you wanted to give us?
It's a phone number for the son who's taken her.
What's this phone number?
775-232-5583.
775-232-5583?
Yes.
Okay. And what was his name? Was Roger? Okay.
Hillygus. And for some reason, he called in here and said he's not bringing her back. He's taking her.
He just did that now?
Yeah, he's on the phone with my executive director.
He's not bringing his mom back?
That's what he said. He said, I'm not bringing my mom back. I'm taking her home with me. But I personally...
You know what his address is?
He lives in Dayton. That's all I know.
Alrighty. I'll let him know, okay? We do have officers in that too.
Thank you. Oh, yeah, they're here now.
Okay. Then jump on.
I am, however, disappointed that you are continuing to represent me after we mutually agreed to terminate our relationship. I realize that you believe me to be incapacitated, and that you think you are protecting me from my son, Roger Hillygus. Nothing could be further from the truth.
Retrieve my mom somewhere? I'm Sergeant Hannafin. I was sent out here by Commander.
Oh, okay. Yeah, but I was talking to him on the phone and we got disconnected.
Okay.
So I said I was real close here, so I just came by.
Yeah, they're busy.
So one of the things that I hung up on, I didn't hang up on him. We just call got lost.
What can I do to help?
Well, I kind of had a dialogue with him, but obviously he's turned over to you now.
Yeah, they're busy, so they assign these things down to me. So
I was explaining to him that I've got a judgment and
do you want to step outside so we can talk? So we're not in front of everybody. That'd be fun.
To keep him away from my mom. So during this whole process, he called in.
He's like, I got all the paperwork, we're giving it to the sheriff and the police, and there's a federal investigation on all these, and he's just rambling it out. I'm like, if you got the paperwork, I need you to do this. Looks, because this is kidnapping, buddy. You took her, you need to bring her back. You don't have her medication, you don't have anything. You're in danger. He's like, no, I know how to take care of her. They need to mail me the meds. No, can't do that. You need to turn around. No. Like, where are you going? He's like, taking her home. Mail the meds to her home.
The daughter said that he lives in Dayton, but I don't know what her old address was, and if we even have that. I don't know.
Pull our file and look. See what we got.
We don't get involved in civil judgments, period. Either side. I don't even care what the judge ruled. The judge ruled that you have full power to walk in there and take the whole facility. That has nothing to do with us. That's a civil judgment. The government has no interest in that, so why would we get involved? So what I'm saying to you is if you get up there, I would bring all your documents. I wouldn't just walk in there and grab her. I'd go see the management of the facility, show them your documents, explain to them.
He is the successor trustee, and the one I have always wanted to be placed in that position. So please consider this your official notice discharging you as my attorney. You are to cease and desist from any further actions, hearings, or petitions with the court on my behalf, or by representing any family member. Respectfully yours, Herbert Eugene Hillygus. The contents of that letter bore the weight of responsibility, as Roger was tasked with carrying forward the legacy entrusted to him. The road ahead was uncertain, fraught with challenges and questions, a path that he was now called to walk. The legal battle in the story centered around the guardianship of Roger's mother. Roger Hillygus believed the guardianship was wrongly taken and fought to regain control. His actions included obtaining a jury verdict document to challenge the system in their pursuit of justice. Roger Hillygus and Stuart Hant engaged in a legal battle. Their actions represented a desperate attempt to navigate a flawed guardianship process, challenging norms and risking their own positions for the sake of Roger's mother. The legal battle encapsulated the tension between personal convictions and established legal procedures, prompting a reflection on the complexities of advocating for vulnerable loved ones within a system that might not always align with their best interests.
So, with Susan's meds, is there anything on this list that, if not taken as prescribed, is life-threatening?
Just Ativan, and Risperidone, and this one for the anxiety.
Well, nobody's ever died from anxiety that I know of, but
No,
as
I
far
don't
as
think
any...
so.
I need you to call down there. 925,000. Try to get back to his medical system and need a prescription of Razepam for the resident.
235.
At first I thought that he would do that because that's what he's done in the past.
Then fax us a script for her so that we can get her some medication so she calms down.
He is married? He is.
He's aggressive.
Some sheriffs had to remove him with the from his house.
From your mom's house?
And the sheriffs wouldn't do it without a court order because he threatened anybody else. And he does have guns, so if they go out to Dayton, they need to be aware what they could possibly be taking.
Okay, but do you understand that my mom's life is in danger right now? In danger.
How?
How?
How? She's with your brother.
Have you heard all the stories that we've been going through?
I understand he has. He may have some.
So you
Okay.
believe that he's not a hazard?
None of your mother's. No, she doesn't. All of her. No, she doesn't. Because I just talked to the med tech because I got a list of her meds, and I confirmed with the med tech because all of her meds are primarily for anxiety, mental health. It's not for. There's nothing physical that if your mom does not take medications, she's going to die from. And I confirmed that with the med tech.
RPD Detective Allison Jenkins filed an affidavit in the Reno Justice Court at 4:03 a.m. August 9th, 2019, 12 hours after Roger Hillygus rescued Susan Hillygus from neglect in Stone Valley. Detective Jenkins used false evidence to support her DA complaint. The affidavit was also used to obtain a Judge Ryan Sullivan's signature on the arrest warrant.
Is in custody this morning after an hours-long standoff in Bellflower that ended at 2 a.m.
So he's accused of kidnapping his own mom from a care facility. CBS 2's Cara Finstrom joining us from the complex where it all happened. And Cara, you spoke exclusively with the woman whose apartment they were holed up in.
Yeah, she's the apartment manager here. She knows him personally. She knows his mother. But like everyone else, she is waiting to learn what's next for both of them.
It's upsetting for me being the manager here. It's 55 units and people want to know what happened. What did he do? What's he running from?
Wilma Dester oversees the Bellflower complex where the SWAT standoff took place. She also lives in apartment Q, where sheriff officials say 52-year-old Roger Hillygus, who's suspected of kidnapping his 80-year-old mother from a Reno care facility, was holed up.
At what point did you realize that he was actually, police were looking for him?
When they rammed on my door.
Dester says Hillygus' mother is her boyfriend's only sister, and he showed up about a week ago asking to stay with them.
He takes good care of his mother, though. He feeds her, he diapers her, bathes her. No, absolutely no mistreating that we could see while they were here.
Dester says she and her boyfriend were in the front room when officers rushed in and were escorted out. Hillygus was in the back with his mother, and she doesn't know exactly what happened next. SWAT officers quickly surrounded the complex. Their night vision images show the force that was in place for hours. Dester says she doesn't have a gun in her apartment and did not think Hillygus brought one. Reno police have been looking for him and his mother since last week. They say he and the former sheriff of Mineral County, Nevada, who's been arrested, went into her care facility, provided false information, checked her out, and called saying she would not be brought back.
I think that was the main thing. He wanted to get his mother and take care of her. But then there's a sister up in Reno that resents this. And what is over, I don't know.
Ultimately, authorities say Hillygus fell asleep and they went in, taking him into custody safely. His mother, who needs to have daily medication, is now being checked out. Dester feels frustration. All this unfolded in her apartment. But more than anything else, she says she just feels sad.
She's very sweet, So she really don't know, what's happening.
And Hillygus was arrested this morning. The sheriff's department has confirmed on an outstanding warrant, which appears to be from Reno. Jasmine DeMarco, at this point, we don't know what possible charges he could face. And at this point, apparently they are still checking out the mom. She has not been taken back quite yet.
You were aware of what happened, right? Here's a little more. Apparently, he shows up with another goon and he says, I'm signing Alice out. He goes and gets Mrs. Hillygus, and there's a witness who sees them pulling her, shoving her across the parking lot. He was pinged in Truckee, apparently. Was that this morning or yesterday?
Yesterday.
And this, really, it's a crime. It's a crime of kidnapping. It could be a crime of, that's a Class B felony, probably. Isolation, elder abuse.
Well,
problematic. Anyway, I don't want to get sidetracked on that. We're here to confirm the property. I'm sorry I interrupted you. The title company is balking at a close any sooner than 30 days because they're afraid that Mr. Hillygus is going to appeal. And I think this is what I'm about to say is true, is a matter of law, that upon sale to a bona fide purchaser in good faith, his cause of action, if any, from this sale is against the trustee and not against the real property. Would you be willing to add that to the order? I'm hoping it gives the title company some comfort so we can get this thing closed sooner.
Any objection to that, Mr. Spitzer? No, Your Honor. I would likely sign. Before we go too far down this, I just want to make sure you don't have any quarrel with this, Mr. Spitzer.
I have no quarrel with that, Your Honor. You do have immediate authority under NRS 159.334 to issue a no contact order under the guardianship statutes.
Mr. Earl?
My only additional thought is under NRS 159.305 that you're dealing with just general exploitation, potential abuse, and so forth. And under those statutes, then likewise, the guardian would have authority or an interested party.
And my thought about a domestic violence protection order is this, is it's registrable. In other words, it'll go into state and national database. And it may have more legs, for lack of a better term, than simply, I of course order that Mr. Hillygus have no contact with a protected person in this case. And that is pursuant to Chapter 159. But let's see if we can establish whether or not there's testimony to warrant a domestic violence protection order. So, ma'am, would you kindly stand, raise your right hand, and take the oath of a witness?
Do you solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Please go ahead and be seated. You can go ahead, if you would be so kind, Mr. Tornabinian, and guide some questioning of your client right there.
Ms. Renwick, are you the guardian, one of the guardians for your mother in this case?
I am.
Her name is Susan Hillygus?
Yes.
And what did you discover yesterday? What happened at Stone Valley?
They let my brother in under a false name, into the facility because there's a whole new administration, new caregivers. So, and he hasn't been there in over a year. So they didn't recognize him and they weren't familiar with the situation. Then they allowed him out thinking that he was the son and he was allowed to take her out, even though in her file, he is not.
So had you and Ms. Bowers, to your knowledge, previously informed Stone Valley that he was not to take her off the premises?
Yes, his name is not on the list of people that are allowed to remove her from the facility. There's a picture in the back room of him, but it didn't look like him.
And to your knowledge, when was the last time he tried to see her, to your knowledge?
Last July. So he hasn't been there in over a year, to my knowledge.
Are you concerned about your mother's health and safety?
Yes.
Okay, why?
He's not familiar with how much she's declined in the last year. She's completely incontinent. She cannot speak. She uses words and she babbles. She cannot answer a question. She cannot she can't tell you how she feels. She can't tell you if she's in pain, if she's hungry. And she only feeds herself at this point half the time. So frequently the caregivers are feeding her. If I'm visiting, I'm feeding her.
So is what you're saying to the court, without the support of the environment of the institution of Stone Valley, her health and safety could be at risk or are at risk?
Yes.
Okay. Did you hear what the judge indicated to issue a order for protection against domestic violence, OBO, you and Ms. Bowers on behalf of your mother?
Yes.
Would you like the court to do that?
Yes.
You believe it's necessary?
Yes.
That's all I have.
The questions you want to ask, Mr. Spitzer?
No, Your Honor, thank you.
Mr. Earl?
Ms. Renwood, could you just describe what you understand to be the situation that arose out in the parking lot that seemed to be important for purposes of the record as to her?
They did not park their vehicle in the parking lot. They parked it across the street.
When you say they, who are you referring to?
I'm assuming it was my brother.
Mr. Hillygus, and whom I refer to as another goon.
Go ahead.
A partner. And so when they started taking her, and her mobility has decreased in the last few months a lot, but she won't stay in a wheelchair because she'll keep getting up. So they were having to literally force, push, and kind of drag her along across the street. That was a long distance for her to walk. And they saw that.
And to whom did you, or from whom did you receive this information?
Tom Taylor, who is an employee at Stone Valley.
Mr. Earl?
And do you have any other details with respect to the car or the nature of the person who was with your brother?
A tall, thin gentleman was with him, is all that I know. And I've just been told by Tom Taylor and another lady that was a former employee there, Lisa Campbell, who saw this happen as well, that it was an older vehicle, looked like an old Jeep Cherokee or a Isuzu Rodeo, which is not a car that I'm familiar with, that my brother owns.
And about what time did this happen?
2:30 yesterday afternoon.
And you were informed right away by Stone Valley?
Once they realized that he was not on the list to take her, they did call me at that point, and I told them he's not allowed to take her, to call the police.
And have you heard anything else from the police?
Yeah, the police gave me some updates last night. They pinged his phone in Truckee, California. They called the Truckee police trying to find him. They sent a police officer out to his property in Dayton, spoke to his wife, and she confirmed that yes, she was aware he was going to be taking my mom, that they were the true guardians, and gave them the We the People documents stating that my brother was the true trustee, and also that he took her to California because he believed that the police would not be able to cross state lines to get her.
Person. Let's move now next to the accounting. Mr. Spitzer, I noted, and Ms. Nelson, of course, noted that the accounting includes check registers without payee information and is, please, I don't mean this too critically, it's just difficult to follow. Any issues you have or concerns you have?
No, that was the major concern that way, and I think it's simply a matter of some more information in regards to the details of some of those expenditures. Other than that, I'm satisfied in regards to the account.
Mr. Earl?
No objections, right?
All right, so the statute requires an account be made and filed, which you folks have done, by the guardian of the estate, other language, who is authorized to manage the property of a protected person, but it must include, without limitation, the following information. All cash receipts and disbursements during the period covered by the account, including, without limitation, disbursements for the support, etc. All expenditures must be itemized. So we just need to know where it's coming from and where it's going to, if that makes any sense. I don't hear a great concern about the accounting at this time, and so I'll ask that you make those changes going forward. I don't want to add an additional expense to the out of control expenses in Ms. Hillygus' life already. I'll simply acknowledge that the accounting is somewhat incomplete, but I have no concerns in light of Mr. Spitzer's comments. So with that clarification going forward, I'll approve the accounting. Finally, there's a request, of course, for fiduciary services fees and for Mr. Torvinen's fees. Mr. Spitzer?
I didn't request fees.
I apologize for fiduciary services fees then. I'm sorry.
Your Honor, this has been a long tortured road. I understand that the amounts are high, but in light of the nature of the work required, I don't have an objection.
Yeah, I note that fiduciary services fees includes invoices for almost $2,000 of fees just to deal with Mr. Roger Hillygus, for example.
And I would suggest, Your Honor, that ultimately the guardian of the estate might attempt to recapture those.
I agree. Let me take an aside in this way. I'm deeply concerned about Ms. Hillygus and her welfare. I dare say I couldn't overstate your concern. It's apparent that Mr. Hillygus has some active mental health issues going on. The filings I'm receiving now are so far removed from reality as to be almost unintelligible, but cause me concern as to his stability. What I mean by that is I intend, if the law would allow me, to retax that 1947 of Mr. Hillygus, but I don't want to push him or anyone else even farther into delusion or psychosis or whatever else may be going on. And so I just intend to be thoughtful about it, is my only comment.
Your Honor, in my involvement in this case and long observation of Mr. Roger Hillygus, I'm not prepared to reach the same conclusion you are regarding his mental state. He is quite a calculating man. He has adopted the constitutionalist type of attitude that those who've practiced in criminal law have seen over the years in people that are perfectly capable in every other way. In regards to those, Your Honor, I think a cause of action to recoup them by the guardian at some later date might be the most appropriate way to do it. Again, anything we do here is going to be subject to some kind of appeal.
Of course. Well, I would welcome the opportunity to decide with the appropriate jurisdiction at the appropriate time whether or not to retax those costs to Mr. Hillygus. Anything you want to add?
I'll just revisit the initial request to sell the property, and on my end, the position has been that the costs and expenses associated with this have been to the detriment of Ms. Hillygus, and to that end, then I would support the order to sell the home as soon as possible.
All right, thank you for that. So I'll approve the fiduciary services costs, noting that any time chargeable to interactions with Mr. Roger Hillygus should likely be reexamined in the future for purposes of taxing or retaxing them to Mr. Hillygus.
I might add there are multiple orders where fees were awarded against him, and I've never done a request for fees, but I will, and this will all be sorted out there. That was my plan.
All right.
May I be heard? I know you got a lot to do.
No, go ahead.
With regard to the TPO, my client is concerned, and she actually made an appearance and was a party in this case, is Debbie Hillygus, whether you would be willing to add the OBO protection for Susan against Debbie. That's Mr. Hillygus' wife. She was a party in this case.
Well, in as much as the evidence I've heard involves no direct action by Miss Debbie Hillygus, at least at this juncture, I would not consider issuing one. I also don't know that Debbie Hillygus falls within the definition of persons against whom a protection order in favor of Susan Hillygus can issue. I just don't know off the top of my head. If you have the statute, we can work through it.
Look it up.
If I can just try and ask one more question of Ms. Renwick. She, in her testimony, she commented that the police contacted her, that she indicated that she was a guardian or they were guardians. Is that what?
Well, no, as I understand it, and please correct me if I'm wrong, Mr. Renwick, the rabbit hole that Mr. Hillygus has fallen down is he believes there is this parallel or other universe through We the People in which he has undertaken a jury trial adjudication of his belief that the court acted without authority, without jurisdiction, et cetera. At most, as to the real property, I issue an order indicating my inclination to confirm the sale, but until the remitter arrives here at the second JD, I don't believe I have jurisdiction. Authority, without jurisdiction, et cetera, so that all of the orders in this case are void. And he believes that jury verdict through this We the People process has enabled him to be the true successor trustee and or guardian of his mom. Is that accurate?
Yes.
All right. Service to the process in this case, if I were to step in out of order any more than I already have, let me be more clear. It's fairly unusual for a district judge sitting with family division jurisdiction, as I do in this guardianship area, to sua sponte issue a protection order. It's been done before. I've done it before. I've never seen a successful challenge to it. And so I believe it's within the jurisdiction of me as a district judge. There is a process, however, in the criminal side. You know, I am now a criminal judge, and I believe the law enforcement authorities are going to have to approach the district attorney's office to seek either a warrant for the arrest of Mr. Hillygus, or they will detain and arrest him on allegations of probable cause. It would not be appropriate, I think, for me to opine at this juncture as to whether or not there is adequate probable cause. I just think that would be stepping outside the bounds of my role at this time. So I appreciate the attempt, but I decline to respond.
Just for a remark for the good of the order, when this first happened yesterday, my clients, both of them, ran into the following milieu. Oh, it's just between a brother and a sister. This is a civil matter, when really it's not. And that's what I'm trying to overcome here. I just want you to understand where that's coming from.
Well, I can tell you that in my view, there are a variety of paths that could be taken to recover the person of Miss Hillygus. More specifically, what I mean is I believe there could be an analogous action for a retake warrant, in the way that if a parent secretes a child in a contested custody proceeding, there is a process to allow me to issue a warrant to include the arrest and detention of the parent or the bad acting parent who has secreted the child.
It would be a UCCJEA.
Correct.
Okay, and is it equivalent in
well, the UCCJEA applies in chapter 159 cases by definition.
Right.
And so there may be a mechanism for a retake warrant, as it were, related to the person of Miss Susan Hillygus. Apart from that, law enforcement is very aware of this case, I can tell you. It would appear to me there is an active investigation. It would appear to me there is some reason to believe that Mr. Hillygus has kidnapped, falsely imprisoned, and or unlawfully detains the person.
In as much as I am a constitutional formalist and very reluctant to in any way be seen as creating law, I give you and Mr. Hillygus notice of the following. In the guardianship case, meaning in GR 14-00159, I take jurisdiction today over the assets in the trust case. That has never explicitly happened before in this case that I'm aware of. The cases have paralleled. They are, of course, in front of the same judge. But I specifically and explicitly today take jurisdiction in the guardianship case over all of the assets owned by the decedent, Susan Hillygus.
I run the show here, not you. That applies for today and forever. Stop talking. Reason. I'm trying to protect you from yourself right now. I haven't made a decision whether your request that your attorney be discharged is granted. Just because you want it so doesn't make it so. I make it so, not you. Your attorney is not relieved until I grant a court order.
Pending before the court today is the big enchilada, the petition for surcharge, but there's also the two accountings for the guardianship, the accounting for the trust, my attorney's fees itself, the release of the additional $22,500 that was agreed to be paid to Mr. Hillygus' wife. That's Debbie Hillygus. I think I got everything there.
Well,
So
first, I apologize for interrupting, Mr. Tordini, but as to any outstanding accountings, the outstanding accountings were lodged long ago. There has been no objection or traverse filed related to those accountings, and I'll simply sua sponte approve the outstanding guardianship accountings and the trust accountings, making easy, if you will, the math related to those accountings and the argument around retaxing of costs, etc.
Her son and a former law enforcement officials were in Reno Justice Court facing charges for her abduction. Ed Pierce was there.
The story that unfolded in this preliminary hearing in Reno Justice Court had its roots in a bitter battle over the guardianship of 80-year-old Susan Hillygus. Her son Roger had lost the legal battle to his sister in 2016, and by August of 2019, she had made plans to sell her mother's home to support her care. By then, she was living in a Reno memory care facility, ambulatory but mostly uncommunicative. He had apparently not given up and even approached Reno Deputy Police Chief Oliver Miller with a strange request.
He wanted to have myself, Chief Soto, Sheriff Darren Balaam, go down there to effect some type of civil arrest against the individuals that were holding his mother in the care facility.
Miller told the court he advised Hillygus the department had no role in what was strictly a civilian matter, and he should hire an attorney and stay away from the care facility where he had already been accused of trespass. Hillygus apparently found a more sympathetic ear in another law enforcement veteran, former Mineral County Sheriff and Reno Sparks Indian Colony Police Chief Stuart Hanty, who Miller said made a similar call to the police department. According to investigators, August 8th, Hillygus went to the care home, told his staff he was there to visit another patient, and took his mother. He later called to say he wouldn't be returning her, but was taking her to California, where authorities would have no power over them. But days later, acting on a secret witness tip, police located them in an apartment in Bellflower, California. He was arrested on second-degree kidnapping charges. Handy admitted his role, but explained he was sympathetic to Hillygus' plight because of his own family's history. His charge was later reduced to conspiracy, but appeared with his friend at the hearing and may share the defense table with Hillygus if this case moves on to trial in district court. Sadly, Susan Hillygus died in October of 2019, a couple of months after her return. In Reno Justice Court, Ed Pierce, Colo 8 News Now.
Battle.
Alex here with an events video on the state of Nevada versus Roger Hillygus, a case involving a man who allegedly, with the aid of retired Sheriff and Police Chief Stuart Hand, went into an assisted living and memory care facility and removed his 80-year-old mother, Sue Hillygus. Reno police tracked Mr. Hillygus to a home in Bellflower, California, and took him into custody after a brief standoff. Interest in this case stems from a flurry of media coverage that followed after a number of guardianship watchdog groups closed ranks around Mr. Hillygus, bolstering claims that his mother, who has since passed, was held in a locked facility against the family's wishes. Prosecutors leveled charges against Mr. Hillygus in Hand, bringing 5 felony counts for kidnapping and unlawfully removing Ms. Hillygus with the use of forged legal documents. We filed a media request, and the Washoe County District Attorney's Office objected. Justice of the Peace Ryan Sullivan decided to hear the objection on the day of a preliminary hearing, at which point Deputy District Attorney Amos Stegg asked that his face not be on camera because he feared for his safety, and requested that Channel 4 News should take over coordination of the camera pool on the basis that he didn't know who we were. Ms. Sullivan rejected his request, barring Channel 4 News cameras in their entirety and pronouncing from the bench that our media request was granted, but proceeding immediately without giving our camera team an opportunity to set up and actually record the proceedings. We filed a request for the JAVS recording, which is now pending, and in the meantime, we'll continue monitoring the case in the hopes that we'll be able to provide coverage of the continued proceedings on March 31st at 1:30 p.m. Mr. Hillygus is representing himself. Mr. Hand is represented by Joey Gilbert. The state of Nevada is represented by Amos Stegg, Tyson League, and Wesley Duncan. You can keep up to date on our coverage schedule by visiting www.ournevadajudges.com, and as with our previous videos, feel free to post any questions you have down in the comments below, or you can send us an email at admin@ournevadajudges.com.
Are you saying that Mr. Torvinen's fees are solely designed? Well, let me ask you this question. Who does Mr. Torvinen represent in this matter, to your knowledge?
The trustee and the guardians.
And who are those people?
Kelly Lund, Fiduciary Services of Nevada, and myself.
Okay. Now, when he's do you understand the difference of him representing you as the guardian or the trustee, and him representing you personally in this action?
I'm not sure.
Well, let me ask you this question. Why is it that all of the work being done, well, I'm sorry, Judge, let me rephrase that question. Have you reviewed the billing of Mr. Torvinen?
Yes.
Have you gone over it with him?
Yes.
Okay. And do you have no issues with that billing?
No.
Okay. You have not filed an objection or anything like that with the court, have you?
No.
Okay. And relative to the monetary division that is to take place in this case, have you attempted to negotiate a lesser fee with Mr. Torvinen other than the now $81,000 fee we're subject to?
Are waning,
yes.
And we'll lose our liberty.
And was the result of those negotiations expressed by Mr. Torvinen on the record?
Left to
Yes.
see.
Okay.
Are you
Now, can you indicate for me,
willing to stand with
and I'm not trying to put you onto the spot here, but can you indicate for me in Mr. Torvinen's billing records the difference between work he is doing for the estate and the difference in work he is doing for you as trustee or guardian?
Separately. Are you
together?
Are you going to the tree?
Your Honor, I object to that question. Working for the estate. The question was working for the estate and working for you as guardian.
It won't
It's the
get
same
any
thing.
easier to regain lost liberty. Strange things are happening in this land.
Well, I guess the
that once
objection,
was
Your Honor,
free.
is the form of the question.
So, brother, I ask
understand.
you,
It's nonsensical.
are
I'm not asking
you,
for additional
are
argument.
you
All right, I won't.
going to stand by me?
Thank you, sir. Thank you, Your Honor. So, is it your intention today to have the division that is on page 10 of the petition be the order of the court?
I object to the extent that that question does not reflect the modification I made at the beginning.
Subject,
Understood.
I'll re-ask the question, Judge. I'll save the time. Subject to the modifications made at the beginning of the hearing, is it your desire to have page 10 be the order of this court today?
Yes.
Okay.
Can you explain for me how it is that at the end of that accounting, Mr. Hillygus' share becomes yours?
Objection, Your Honor. That calls for my client to give a legal conclusion.
Same. Next question.
Okay. So are you aware that the remedy that is being sought by Mr. Torvinen is for you to get the entire 152,150, I'm sorry, 100, the number changed, whatever the number was at the beginning of the hearing, that entire balance is your sole and separate property. You do understand that's the relief he's requesting?
Yes.
Why do you believe you're entitled to that?
I believe that none of this would have even happened if it weren't for Roger's bad faith starting in 2013. I believe all the attorney fees should be charged to Rogers.
Are you going to agree? Our freedoms are waning and we'll lose our liberty, slipping one by one until there's nothing left to see. Are you willing to stand with me? Are you just going to let it be? The ranchers are first, but brother, next it may be me. We all stand together or we'll hang separately. Are you going to the tree? Are you willing to be free? It won't get any easier to regain lost liberty. Strange things are happening in this land that once was free. So, brother, I ask you, are you going to stand by me?